Hi, I'm Ashley Heidemann. I'm the founder of JD Advising. In this video, we're going to talk about some MBE favorites. So these are issues that you will likely see tested in some form on a multi-state bar exam practice test or hopefully the real multi-state bar exam. These are issues that we've seen tested repeatedly in released MBE questions. Note that released MBE questions are questions that have been released by the National Conference of Bar Examiners. The National Conference of Bar Examiners, or the NCBE, is the organization that writes the multiple choice portion of the bar exam. So these are the absolute best questions because they are administered or distributed by the actual organization that writes the questions themselves. So these are the closest thing that you're going to see to the real bar exam questions that you'll actually see on your exam. Note that the 5 questions that we cover today are not real bar exam questions. These are questions that we've actually invented. The reason for that is because if we gave you real bar exam questions, we'd have to keep close track of who downloads this PDF and watches this video. We'd have to make you agree to certain licensing terms, and we'd have to pay a licensing fee to the National Conference of Bar Examiners. So to avoid all of that and to make this more widely available, we decided to craft our own questions based on issues that the NCBE likes to test. So with that, we'll cover 5 MBE favorites for civil procedure. The first MBE favorite for civil procedure that we're going to cover is one on service of process. So let's look at the question and then we'll talk about the answer choices and how to dissect this type of question if you see it on the actual bar exam. Okay, so turning to the question. A customer filed a tort lawsuit against her neighbor in federal court. The customer's attorney served a summons and a copy of the complaint to the neighbor by slipping the summons and the copy of the complaint under the neighbor's door while the neighbor was at the grocery store. The neighbor promptly noticed it upon arriving home. The state rules on service of process are identical to the federal rules. Was the neighbor properly served? So before we even look at the answer choices here, we should see whether or not we know if the neighbor was properly served. It's often helpful when you practice MBE questions to go through the rules and see, do you actually know the rules? Because if you can't actually state the rule, then you'll end up guessing on some of these MBE questions that test this highly tested rule, and that means you'll probably get some of them wrong. So make sure you have the rule down cold. If we look to the rule on service of process, it says this. Under the federal rules, service may be completed in 4 ways by someone who is 18 years old, at least 18 years old, and not a party to the case. And our mnemonic that we use for this is SAID. So S is state law. Follow the state law methods where the federal court is located or where service is made. If we look at the facts, it says that the state rules on service of process are identical to the federal rules. So we're not going to have any special state law rule we apply here. So we know that the neighbor was not served under a special state law rule. A is agent. Deliver a copy of each to an agent appointed by defendant or law. In this case, we don't see the neighbor's agent being served, so we can cross off this. I is individual. Deliver a copy of the summons and complaint to the individual personally. This means that you're actually handing it to the individual. In this case, the neighbor did not receive individual service because it was just slipped under her door. So she was not properly served using this method. And D is dwelling. Leave a copy of the summons and complaint at the individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there. Some students think that this is the right answer choice, but here the summons and complaint were not actually left with anybody. They were just slipped under her door. Note also that some students get confused and they think because she got actual notice of the lawsuit that this counts as proper service of process, but it doesn't. In order to be properly served, you have to be served in one of these 4 ways. So actual notice isn't going to be the key factor to determining whether or not this woman was properly served. Now, if we look at the answer explanations, we've gone through all 4 of these and we've said that so far it looks like the woman has not been properly served. So we want to look for an answer choice that says no, the neighbor was not properly served, And if we find a no answer choice that matches up with this rationale, then we're probably in good shape. So let's look at the answer choices. C says no because the attorney for the plaintiff may not properly serve the neighbor. Now, this isn't correct because an attorney for the plaintiff may serve the neighbor. If you go back to our rule statement, it says under the federal rules, service may be completed by someone who is at least 18 years old and not a party to the case. However, a party's attorney may serve someone. When I was in litigation, I used to have to serve people if we were running up to the statute of limitations because we wanted to make sure that we got it to them in time. So it's possible for an attorney for a party to serve someone. If we go to answer choice D, it says no because the summons and complaint were not served to the neighbor personally or left with a person of suitable age and discretion who resided there. And that sounds right. It says that, it's recognizing that an individual was not served and it was not left at a dwelling with someone of suitable age and discretion who resided there. So D is looking like the right answer choice. Now we want to go to A and B and make sure that we're still confident in our answer choice. A says yes because the neighbor received actual notice of the lawsuit. Remember that actual notice of the lawsuit is not the determining factor. You still have to be properly served using one of these 4 methods. So this isn't correct. And B says yes because serving the neighbor at their place of abode is permissible under the federal rules. And it's true that serving the neighbor at their abode would be permissible under the federal rules. However, in this case, it's not permissible because the summons and complaint were not left with someone of suitable age and discretion who resided there. It was just slipped under her door. So if you know the rule for this one, you should get all of these service of process questions correct. And it is tested a lot because it's nuanced and people don't like to memorize the rules for service of process. Alright, our next MBE favorite is impleader. So let's look at a question that tests impleader. A woman was domiciled in State A. She filed a lawsuit in federal court seeking $100,000 in damages against a construction company that was one of several contractors that she hired to construct her office building. The woman alleged that the construction company was negligent. The construction company was incorporated in State B and had its principal place of business in State C. The construction company stated that the woman sued the wrong party as it was really the building company that was negligent and responsible for the woman's damages. The construction company alleged it did not even work on the portion of the building that the woman claimed was improperly constructed. 10 days after serving its original answer, the construction company timely asserted a third-party complaint against the building company, which was incorporated in State B and had its principal place of business in State A. So here's the facts. Oftentimes when you see a fact pattern that's a little bit convoluted and has a lot of states mixed into the facts, it's very helpful to diagram it out and draw out what the facts are. Note this only takes 30 seconds or less to diagram this out, and you can do it while you're reading the question. So this will ultimately save you time on the MBE. So if you struggle with timing, it's helpful to diagram these out as you read the question. So get a good system in place, and then make it a habit to do this while you practice as well. So here's an example of a diagram. You can see the woman, and we have State A under her because the facts tell us that she's domiciled in State A. Remember, an individual is domiciled where it's their permanent home where they intend to stay indefinitely. Here, the facts just tell us that the woman was domiciled in State A. So that's how we know that. Then we see that she's suing a construction company, which is domiciled in State B and State C. How do we know the construction company is domiciled in these states? Well, remember that a corporation is domiciled where its principal place of business is and where its articles of incorporation are filed. So a corporation can be domiciled in 2 states. Here, the facts tell us that the construction company was incorporated in State B and had its principal place of business in State C. Then we see that the construction company wants to implead this building company, and the facts tell us that it's incorporated in State B and it had its principal place of business in State A. So these are the facts, and again, it's very helpful to have a diagram like this because if you have a good system, you can just quickly jot this out and keep the facts straight in your head. Okay, so if we go back to the call to question, it says, what is the best argument to achieve dismissal of the third-party complaint? Now, you might be wondering what a third-party complaint is, and let me give you an example. Essentially, a third-party complaint is alleging derivative liability. So you're arguing that if you're liable, someone else is liable to you for some or all of the harm. So for example, let's say that you and I are both driving on a road, and I stop, and your car slams into the back of my car. So I sue you for something like negligence. you might implead, let's say, the taxi driver who was behind you who had crashed into your car. And you might say, the only reason that I hit your car, Ashley, is because the taxi driver collided into my car. So you would implead the taxi driver, saying that if you're liable, they will be liable to me, the plaintiff, for some or all of the harm. You can still deny liability altogether. Your argument is merely, if you're liable, then that person is really the true party that owes some or all of the damages that I'm claiming. So that's when an impleader is appropriate. That's when filing a third-party complaint is appropriate. It's not appropriate if someone's just alleged that you've sued the wrong party. Like, let's say you collide into my car and I sue you, but really it wasn't you at all. It was your twin, your identical twin, that had hit the back of my vehicle. So if I filed a complaint against you, it would not be appropriate for you to file an impleader complaint against your twin. Instead, you should file a motion to dismiss because your argument is that you're not liable at all. You're not saying, if I'm liable, it's really my twin's fault. You're just saying, I'm not liable, plaintiff sued the wrong party. So if the argument is that the plaintiff sued the wrong party, then an impleader is not appropriate. Now let's look at the answer choices to see if we can find one that reflects that type of rationale, or that reflects the rationale for an impleader complaint. So if we look at the answer choices, both A and B have to do with diversity. When they ask what's the best argument to achieve dismissal of the third-party complaint, A says the third-party claim destroys diversity jurisdiction as the building company is incorporated in State B. So if we go back to our diagram, it's concerned that the building company and the construction company are both incorporated in State B. And answer choice B says the third-party claim destroys diversity jurisdiction as the building company has its principal place of business in State A. So again, looking at our diagram, we can see that the woman and the building company are from State A. Note that both of these are incorrect. And the reason that they're incorrect is because a defendant is allowed to implead a non-diverse party. You don't even take that third-party defendant's domicile into account when looking at diversity jurisdiction. The plaintiff cannot sue that building company directly. The plaintiff cannot sue that non-diverse party, but here we don't see that happening. So if you want to start getting more of these questions right, particularly those that test supplemental jurisdiction, remember that impleaded third party, in this case the building company, is not taken into account at all when looking at diversity jurisdiction. So we don't care that they're from the same state as the defendant or the plaintiff. So A and B are both incorrect. If we look at answer choice C, it says the construction company did not seek leave of court prior to filing a third-party claim. And it's true that in some cases you do need to seek leave of court, but generally this is only if the defendant does not file a third-party claim within 14 days after serving its original answer. And the facts here state that the construction company timely asserted a third-party complaint just 10 days after serving its original answer. So C is not correct because the construction company would not need permission from the court to file this complaint. So let's hope D is right because this is our remaining answer choice. D says the construction company did not properly assert a third-party claim. And if we look at the facts, let's go back to the fact pattern and let's look at what the construction company's argument is. It says the construction company stated that the woman sued the wrong party as it was really the building company that was negligent and responsible for the woman's damages. It also says the construction company alleged it did not even work on the portion of the building that the woman claimed was improperly constructed. So essentially, the construction company's argument is that the woman sued the wrong party. Apparently there were a lot of contractors on the scene and she just got it wrong. She shouldn't have sued the construction company at all. She should have sued the building company. Well, remember, if your argument is, it's not me, it's my twin, or it's not me, it's the other party, you sued the wrong party, a third-party complaint is not appropriate. Rather, a motion to dismiss is. So the best argument to achieve dismissal of the third-party complaint is simply that a third-party complaint is not appropriate in this situation. Or as answer choice D says, the construction company did not properly assert a third-party complaint. This would not be the type of third-party complaint that you would assert because this is not alleging derivative liability. All right, so we covered a lot about impleader, diversity, domicile, all kinds of things with this question. So hopefully if you see an MBE question that tests any of these issues, you will answer it correctly. The next MBE favorite that we're going to cover goes over the Claxon rule. And this is truly one of the NCBE's favorite rules to test. It's in their recently released MBE study aid. It's tested in their sample MBE questions online where they only give a handful of civil procedure questions. This is one of the issues that they test. And it's something that if you're in a uniform bar exam state or a multi-state essay exam state, that you could easily see on the essay portion of the bar exam too. It's tested with choice of law questions. So with that said, let's look at this tricky question and we'll talk about how to approach this type of question if you see it on the bar exam. A woman from State A was injured while swimming at a hotel pool in State B. The hotel chain was incorporated in State B and had its principal place of business in State C. The woman sued the hotel chain for negligence in a federal court in State B, seeking over $200,000 in damages. Which law of negligence should the federal court apply? Now let's look at the answer choices for just a second. I know this typically breaks the rule that I tell everyone to keep, which is to try to think of the answer choice before you look at the answer choices. But let's go ahead and look at them. Which law of negligence should the federal court apply? The law of State A, the law of State B, the law that the State B court would apply, or the federal common law of negligence. This is a hard problem. It's an MBE favorite. So let's look at the facts. Because what do we see in the facts? We see a woman from State A, and hopefully you were jotting out a little mini diagram of this as you were going through this. And she was injured while swimming at a hotel pool in State B. It tells us the hotel chain was incorporated in State B and had its principal place of business in State C. It also tells us that the woman seeks over $200,000 in damages. So the requirements for diversity jurisdiction are met. Remember, for diversity jurisdiction, the plaintiff needs to be seeking over $75,000 in damages, and the plaintiff and the defendant need to be diverse. In this case, they are because the woman is from State A, and the defendant is from States B and C. So this is a proper diversity jurisdiction case. We also see that she's suing in federal court, and that this is a state law claim. So it's not a federal claim. So what is a federal court going to do? Now normally when you see a state law claim in federal court on diversity jurisdiction, this raises an Erie issue, everyone's favorite. So remember that a federal court is going to apply the federal procedural rules to an Erie case, but it will apply the state substantive law to an Erie case. And why is this? Well, federal courts don't want to constantly change up the laws that they apply for procedure. So if they have certain procedures, rules, timelines, deadlines, how things should be done, when things should be done, they're going to apply their own rules because it's not really supposed to make a difference in the outcome of the case. And more importantly, no one is going to forum shop and go to federal court over state court because of some different timeline or some different procedural rule that the federal court follows. Federal courts want to get rid of cases. If you know any federal clerks, they will tell you their goal is to get cases out of federal court a lot of the times, okay? So if they can find a way to get out of federal court, they will. And they certainly do not want to encourage anyone to go to federal court over state court. Like they would prefer that this woman who was injured at the swimming pool file her case in state court because it would be one less claim for them to hear. So they do not want the outcome to be any different in federal court than it would be in state court. They want the outcome to be the exact same. So they're going to apply the state substantive rules. This also includes choice of law principles. They're going to do whatever that court would do in State B because they do not want the woman to forum shop and go to federal court hoping for a different result than one that the State B court would reach. So let's look at the facts. Here it says that she's suing in federal court in State B, seeking over $200,000 in damages. What law of negligence is the federal court going to apply if they want the outcome to be the exact same as it would be in a State B court? Well, they're not going to apply the law of State A because State A might use a different choice of law approach than State B. A lot of people want to jump to answer choice B and say that they're going to apply the law of State B. But in this case, that's not exactly right. If you studied conflicts at all, you would know that each state has their own choice of law approach. So a lot of them, especially in a tort claim like this, will look at 4 or 5 or more factors to figure out which state's law should apply. Like if someone was injured in State A, the conduct causing the injury was in State A, both parties were domiciled in State A, but yet they sued in State B, even a State B court would likely apply the law of State A. The point is the State B court is going to use its own choice of law principles in determining which law to apply. It's not going to just blindly apply State B law. So that's why answer choice B is incorrect. Answer choice C says the law that the State B court would apply. This is absolutely correct because the federal court wants the outcome to be the same as it would be in state court. And a State B court would apply their own choice of law principles. So the federal court is going to apply the same exact choice of law principles that a State B court would apply, hoping to reach the exact same result and discourage forum shopping in the process. If we look at answer choice D, it says the federal common law of negligence. This isn't right because a federal court is not going to apply their own common law to this state law substantive issue. It's going to apply the appropriate state rule, which we've discussed. So this is a hard issue. The Claxon rule is tricky, but it's important to know because it is tested on the MBE very regularly. A lot of people get it wrong, and it's even more important if you are in a UBE or MEE state because you might even see it on your essays. So the next MBE favorite that we're going to discuss is the two dismissal rule. This one shows up in released questions. A lot of people don't know it. It's just one simple little nuance, but it's worth it to know in case you see it on the actual bar exam. So let's look at the question. A woman filed a lawsuit in federal district court against her employer for violating the Federal Fair Labor Standards Act. 10 days after filing her complaint, and before the employer served an answer to the complaint, the woman became ill and voluntarily dismissed the action. 6 months later, the woman filed the same claim in the same court. 5 days after filing her complaint, and before the employer served a response to the complaint, the woman's daughter became engaged. The woman voluntarily dismissed the action since she knew she would be busy helping her daughter plan her wedding and could not dedicate sufficient time to prosecute her lawsuit. 1 year later, the woman filed the same claim in the same court. Okay, so just to recap on the facts, here we have a woman filing a complaint, then she voluntarily dismisses it before anything's filed by the defendant because she became sick. Okay, that's fair. Then she files it again and voluntarily dismisses it again because her daughter became engaged. The two dismissal rule states that she cannot file it a third time. So let's actually read the rule together. Under the Federal Rules of Civil Procedure, a voluntary dismissal by the plaintiff is without prejudice unless the plaintiff previously dismissed any federal or state court action based on or including the same claim, in which case a notice of dismissal operates as an adjudication on the merits. So this is a fancy way of saying if a plaintiff voluntarily dismisses a complaint once before a response is filed, it's without prejudice, meaning the plaintiff will not be prejudiced against. She can refile that same complaint again later if she wants. But if she does it twice, it's going to operate as an adjudication on the merits, meaning she cannot refile it again if she voluntarily dismisses it twice. She'll be precluded from filing it again. It says this is known as the two dismissal rule. Thus, the plaintiff can dismiss a claim once prior to a response being filed, and she may bring it a second time, but she cannot dismiss it twice and bring it a third time. So that's the essence of this little nuanced rule. It just says you can dismiss a complaint once voluntarily, and you're allowed to refile it again, but you can't do it twice. And they like to test this little nuance, so it's good just to keep it in mind. Now, let's go to the answer choices. Here, it says, is the woman's claim barred? And if we just apply the rule, it should be barred because she has voluntarily dismissed the complaint twice now, so she should not be able to bring it a third time. A says yes because the second time the woman dismissed the claim, it operated as an adjudication on the merits. And that's correct. She dismissed it twice now, so that operates as an adjudication on the merits. She cannot bring it a third time. B says yes because issue preclusion prevents the woman from bringing the claim again. Issue preclusion actually would not prevent the woman from bringing the claim again, because remember, for issue preclusion to apply, it has to be the same issue that's been actually litigated and determined that has been necessary to a final judgment on the merits. Here we do not have any type of issue preclusion in this case because the issue is not actually litigated or decided. C says no because the woman dismissed both of the prior actions before the employer answered the complaint. And this isn't quite right because the two dismissal rule will prevent her from filing this a third time regardless. D says no unless the employer can prove she is refiling the claim with the goal of harassing the employer. The employer does not have this burden. All the employer needs to do is prove that she's filed the same claim twice, and the two dismissal rule will prevent her from filing it a third time. Okay, now we're going to talk about our last MBE favorite, which is venue. So let's start by reading the question together. A plaintiff and a defendant were involved in a motorcycle accident in State A. The plaintiff filed a negligence action against the defendant in the federal court in State B. The defendant filed a motion objecting to venue. The plaintiff is a citizen of State B. The defendant has a home in State B and State C. The defendant spends most of the year in State C, but spends a few weeks of the year in State B where he owns a vacation home. Each state only has one district. How should the court rule on the defendant's motion? So the easiest way to answer this question is to make sure that you have the venue rules memorized. So let's look at the venue rule and then we'll talk about what it means. So the general rule for venue says this. Under the federal venue rules, venue is proper in a district where any defendant resides if all defendants reside in the same state, or in a district where a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is subject to the action is situated. I put in parentheses that there's also narrow fallback rules. So there are some fallback rules which state if neither of these situations apply, here's what else you could do to determine where venue is proper. I've never seen those rules tested on the MBE, so I would just focus on learning the general rule for now and making sure that you have that down cold before you try to memorize any fallback rule as well. So if we break down this rule, it says that venue is proper where any defendant resides if they all reside in the same state. If you're only suing one defendant, you can sue that defendant in the district where they reside. They're not going to complain because they don't have to travel too far if they reside in that district. And same thing goes if there were multiple defendants. If they all resided in the same state, you could sue them where any one of them resided. Here we learn that each state only has one district, and we have to figure out where the defendant is domiciled. It says the defendant has a home in State B and C. He spends most of the year in State C and only spends a few weeks of the year in State B in his vacation home. So if he only spends a few weeks of the year in State B where he owns a vacation home, he's technically not domiciled there. Remember, a person is domiciled wherever their true home is, and that is where they live and intend to remain indefinitely. So if you have a home in another state, that's not where you live and intend to remain indefinitely. So here, the defendant is likely domiciled in State C, but not State B. Okay, so it would have been proper for the plaintiff to sue and to file the action against the defendant in State C, because that's where the defendant is domiciled. The next place where the plaintiff could file the action is where a substantial part of the events or omissions giving rise to the claim occurred. And if we look at the facts, it says that the plaintiff and defendant were involved in a motorcycle accident in State A. So the other choice that the plaintiff has in terms of where to file this lawsuit is in State A, because this is where the actions that gave rise to the claim occurred. However, in this case, unfortunately, the plaintiff decided to sue the defendant in federal court in State B. This is not where the defendant resides, and it's not where a substantial part of the acts or omissions giving rise to the claim occurred. So this is likely the improper venue. So when we go to the answer choices, when it says how should the court rule on the defendant's motion, we want to find an answer choice that reflects that State B that is not the proper venue, so the motion should be granted. So let's look at answer choice A and B. A says it should grant the motion because the defendant is not a resident of State B and the accident did not occur in State B. That sounds very good. In fact, that's exactly what we just said. Let's look at the other answer choices. Regardless, B says it should grant the motion unless the defendant was living in his State B home at the time the accident occurred. We don't look at where someone was at the time the accident occurred in determining their domicile. We look at where their true home is and where they intend to remain indefinitely. So even if he was on vacation at his vacation home at the time that the accident occurred in State A, it still wouldn't make a difference. He's still considered to be domiciled in State C. Okay, C says it should deny the motion because the defendant has continuous and systematic contacts with State B, thus it is fair to sue the defendant in State B. Continuous and systematic contacts is the type of language that you'll see with a personal jurisdiction analysis, and specifically whether or not a court has general jurisdiction over a defendant. Be sure not to mix this up with a venue analysis where continuous and systematic contacts really don't matter for these two venue rules that we discussed. And D says it should deny the motion because the defendant is domiciled in State B. Again, here, if you look at the fact pattern, it says that he only spends a few weeks of the year in State B and that's where his vacation home is, but we don't have any facts that indicate that that's where he lives and intends to remain indefinitely. So the better answer is that the defendant is domiciled in State C, so State B is not appropriate. Alright, I hope that you enjoyed these MBE favorites tips. We'll definitely be having more of them to come, so please stay tuned if you're interested in hearing MBE tips on other subjects. Thank you so much.